Okay, so I hope we are recording now.
Mhm.
So as I was saying, in Utah, the first statute that we have that authorizes a person to obtain a sex marker change was Utah Code 26211 that was passed as part of a broader Model State Vital Statistics Act. Utah didn't adopt the entire act, but did adopt portions of it. Now, before I go any further, I want to mention something interesting that Utah did when it adopted that act. The Model State Vital Statistics Act, portions of it came from New York, and some legal workers there who wanted to build a model act. And they wanted to include rights for the transgender community. And at the time when this original act was promulgated or made by the respective minds, there was a belief that including a surgical obligation was an intelligent decision. Now, that was recommended in part by some members of the psychiatric community, some legal experts. For that reason, it was considered at the time to be a progressive inclusion in the act. Now, looking back, we see why adding that surgical obligation was very problematic constitutionally and legally. And many states have ended up winding back those obligations. In Utah, there was a provision that said by surgical operation that was never included in Utah's act. There's no legislative history. I've reviewed the legislative history on this, and there's none that can be found, or that I have found, that would explain why this was removed. Regardless, it is something that we have used to district courts to buttress our argument, in addition to our constitutional arguments that any surgical obligations being suggested by district courts are inappropriate. So in the history, we start with this Model State Vital Statistics Act, and we have some case law interpreting name changes. Crushlow and Porter were two very central cases, and the Utah Supreme Court made two findings that are really critical, two rulings. The first is that this Model State Vital Statistics Act and the right to obtain a name change, these are common law rights that predate Utah 26211. And Utah, in adopting that act or that code, simply adopted the common law. That was a really helpful ruling for us today as we argue the parameters of obtaining a sex change in Utah. And the reason is that when the court recognized that these were simply a codification of the common law, we also recognized that these statutes didn't abrogate the common law, that every right that you had up to that moment the statute was passed continued through it. So we've used that argument as well to support the fact that Utah recognizes both name changes and sex or gender marker changes. The purpose the court articulated, and this is the second point I wanted to mention, in adopting this is to bring consistency in documentation. Imagine for a moment a situation where somebody adopts their own pseudonym. I go from Kyler to being James. And then every document I have with the federal government recognizes me as Kyler. Every document I have with the state government recognizes me as James. You just get to a situation where it's not effective or an efficient mechanism. The state focuses on itself and how it will manage itself. And in many ways, we look to how these documents will be used by the state actors who need them, TSA agents or police officers. If you're stopped and your state documents say one thing and your federal documents or their database says something else, that presents both a risk to the state actor, who is at that point cautious, and to the person who is subject to the state action. And so the goal of these statutes is to reduce the confusion, reduce the problems, and to ensure consistency. And I think that there's some inference that we focus on substance here or merits or morality or concepts beyond the stretch of simply the statutory language, and that's not the case here. I now want to turn to the fact we have a code. We have 26211 that grants people the right to obtain a name and sex change. And to me, that leads to the next question of why we're here at all. if we have a code, a provision in the code that specifically establishes an entitlement, why do we have an appeal? Why do we have questions? And the answer is that the code does not establish any specific requirements that a person must satisfy in order to obtain a sex change, which is how the code frames it or phrases it. I represented a client, me and Christopher Wharton, my law partner, in 2nd District, which is north of Utah, or north of Salt Lake City, excuse me. And we received a denial of that. And the articulable basis was that there was no standards by which the court could adjudicate the sex change. We've appealed that, and the Supreme Court is currently considering that question. But the way we have framed this argument is that we have a very clear code. And even though we don't have elements or factors that must be specifically defined, we know under the Utah Constitution that our courts are courts of general jurisdiction. They're there to solve problems. And where the legislature has acted and has given them authority, we want to respect that discretion of the legislature, and we want to make sure that that is allowed to continue. So the goal in interpreting a statute is to give effect to the intent of the legislature when they adopted it. And the way we get at that intent is the plain language of the statute itself. So if we can resolve the question presented by looking to the text, we just look to the text. And in Utah, the code specifically says that a district court may issue an order for a name or sex change that a person may take to a state register, may take to the Department of Vital Records and Statistics in order to have their document changed. In essence, what that statute does is direct one portion of government, the courts, to tell another portion of government, an administrative agency, a portion of the executive branch, to conduct an action. In this case, to change a government record to reflect an updated informational status, either a name or sex or gender marker status. We, in arguments to the Supreme Court, have suggested that the only limitation in the code is the word sex change, to transition from one state to another. We've also pointed the court to the fact that in another portion of Utah's code, we have the Fair Housing Act and Non-Discrimination, where we do have an understanding of a sex change. We do have an understanding of sex and gender, and that they are synonymous under the code. We also have an understanding from that there are anti-discrimination provisions in housing. And the code, in defining what it means to be a transgender person or to fit within that category or status, specifically turns to the WPATH standards, to the DSM-5. And the reason that that is so relevant is because the canons of statutory interpretation tell us that if there is an ambiguity that the text alone can't resolve, we have to turn to the canons to determine how to interpret it. Now, I don't think the canons are necessary in this situation. I think that a fair interpretation of this statute allows a person who is pursuing a clinical transition to obtain a sex and gender marker change. And that, from there, I kind of want to merge into the practical. That's the background, that's the theoretical, that's what's happening in the legal arguments. But from a ground level perspective, a person in Utah can obtain a sex or gender marker change by filing a petition with the district court in the district in which they reside. And for specific, I want to incorporate X gender markers into that. Many Utah district courts have long recognized a person's right to change their gender marker from male to female or from female to male. We have obtained gender marker changes from either male or female to an X designation. Now, the federal government has provided insight into this, and I believe there was a regulation promulgated under the Obama administration that helped provide some guidance there and allowed people to some extent to address those with federal documents. Now, I don't want to deal with federal documents today. There are some cases pending on passports and X gender marker designations, but I want to focus on the X gender marker designations for Utah state law. and therefore for birth certificates and passports. Now, it's important to note that we have obtained orders of X gender marker designations from district courts in multiple districts across the state, and those have been recognized by the Utah Division of Motor, or by the DMV and by the Office of Vital Records and Statistics. In the first case that we got an X-gender marker designation, the DMV noted that their forms didn't really have an X-gender marker allowance. And so we worked with them to change their forms to allow for that. And it's now my understanding that if you have a state court order granting you an X-gender marker designation, that the DMV and the Office of Vital Records and Statistics have been respecting those. The reason that the DMV, who testified at a committee hearing, or subcommittee hearing, I believe, at the legislature, was that federal guidelines suggested that this was appropriate, that this was something that the Utah DMV would be seeing from other states and that Utah could be issuing. This was something that federal documents might register. And so going back to those overarching principles that I mentioned, we don't want, as a matter of public policy, massive distinction in an individual's documentation between federal and state governments. It creates confusion for the state actors themselves. It underpins the very purpose of allowing people to have a formal mechanism by which they could change their name and gender marker, or sex gender marker, excuse me. That is particularly relevant in this instance because if the state actors who are focused on protecting start seeing irregularities or distinctions, then they themselves and the citizen are both subject to confusion, frustration, embarrassment, animosity, potential harassment. And these are the exact things that we're trying to avoid here. So under the Utah Code, the analysis remains consistent. A change has occurred, a transition from one state of being to another state has occurred. To the pragmatics, what we have submitted to district courts in order to evidence this change is a letter from a prescribing physician, if there is any medical component to the transition, a clinician's opinion statement regarding the person's transition through the DSM guidelines and through the WPATH standards. And then, of course, we also submit any documentation that is necessary to show that the person has held themselves out consistent with their gender identity and that the person has made efforts to medically transition from one state to another. These have been very successful in the districts that we have represented. Now, as I noted before, the second district has been kind of a black hole since this appeal, with many cases being stayed, other cases being put on hold informally, in some cases the individual decides that it's not the time to pursue their case. But outside of the second district, I'm aware of X-gender marker designations proceeding in the third district, proceeding in the fourth district. There has been some confusion by judges who have had judicial conferences on gender marker changes, but those conferences, to my knowledge, have focused primarily on changes from either male to female, female to male. And X-gender marker designations have been a new aspect of these cases. I think the most important step that can be taken for an individual seeking an X-gender marker designation is to educate the judge on the statute and to educate the judge on why a X designation is something that has happened, something that is permissible under the statute, and is something that fits within the policies of Utah 26-211, primarily the policies of preserving consistencies and preventing harassment and confusion and embarrassment. In our arguments to the Supreme Court, in addition to the statutory arguments, we have argued that there is a written law right to obtain a gender marker change. Again, again, this relates to goals and the policy statements that 26211 encapsulates, but it also goes back into the history. And it relates to the evidence that we would want a person to submit in these types of hearings. In our briefing to the Supreme Court, we noted that the common law right to change your name was very old. It predates the forming of our own country. We cited cases that discussed Voltaire, that discussed Napoleon, and their de facto changes of name. And as governments built up around them, the governments needed a mechanism to follow these individuals and preserve them in the records. And so as we move forward, if the federal government is permitting X designations, or if the state government is, that's where we would want to really take advantage of the consistency argument and make it clear that failure to consistently permit people to change their documents would just create a system that is ineffective for everyone. And so that's where the medical component is. It speaks to the change aspect that the court will be considering. Has there been a transition from one state to another? The clinical, the therapeutic, and the medical components are all critical aspects. It's also important to get the testimony on the record regarding holding out. For names, it's been a critical element that you demonstrate that you've held yourself out consistent with that name. People adopt pseudonyms and names that they go by before filing, and that's a component that needs to be testified to in the underlying petition. Now, for X-gender marker designations, there is no form that Utah has adopted that clearly describes the language. For this, reaching out to legal counsel can be very critical because it will make sure that there are no procedural flaws in that petition. I think that I've been advising clients more and more recently that have had some problems either with the denial or some similar type of issue because of a procedural flaw. There are several clinics available. There are several things available that we're trying to get going and get off the ground that would help alleviate these. My personal goal is that as we get a ruling from the Supreme Court on this issue, I'm hoping to get an institutionalized mechanism, assuming that the appeal is granted, get an institutional mechanism that can try to increase the individual's access to this relevant information. All of that being said, I think that X-gender marker designations have been met with an increasing level of resistance by some judges. While the overall trend does seem to be in favor of granting X designations, I don't think that this is, this is not a uniform approach. Unfortunately, the current appeal being presented to the Utah Court of Appeals is consolidated and represents a male to female client and a female to male client. However, there is not the issue of X designations. So again, this is a situation where follow-on litigation may be necessary, and as states across the country address this issue and figure out how to ensure consistency across state and federal documents, I think the issue of X designations is going to become so much more relevant. That pretty much covers, I think, the bulk of the substantive information I wanted to cover, the history and kind of the pragmatics of filing. Unless, Brandon, maybe if you have a different opinion, my thought is we could see if there are any questions.
Yeah, if you're okay with taking questions, Kyler, we can use the chat, or if you're okay with folks unmuting themselves if they have a question, now would be the time.
I'm fine. I mean, if we can, I'm happy to read questions, or if anyone has any questions, I think I'll pull up the chat actually, I think. Oh, there it is. So if anyone has any questions, they're welcome to just unmute themselves and ask. I'm happy to answer any questions I can.
Awesome. I have a question. Is there a designated website or somewhere online where folks can find the paperwork that they'll need to begin this process?
Again, the forms are not specific to X gender markers, and so would need to be modified. And it's my understanding from reviewing the forms most recently that they would need to be modified in many instances, even to address a sex change of any form. And for that reason, you'd have to modify them. But there are forms available. You can go to utcourts.gov. It's the state court website. In that, there's a search engine. You can look for adult name changes. My recollection of the search engine is that you could look for you could say adult sex change and it would pull up the name change page. But I don't know if it's been broadened beyond that. So I would advise everyone it's easiest to access it through the name change search engine. You can also just look up Utah Code 26211 on utcourts.gov, and it will give you a link to a list of forms that can help you as you investigate and look for the forms that you need. Just to kind of give a broad overview, when you are seeking a name or gender marker change, you initiate that by filing a petition. You support that petition, by filing typically a letter from your doctor, a letter from your clinician, and any letters from if there is a surgeon who has performed a surgery, sometimes we submit those letters in addition, just to provide that update to the court. But again, as I mentioned at the beginning, it has been my view and my interpretation of Utah law that that's never required. So those forms you would submit, you'd request a hearing, and there is a request for hearing form on the utcourts.gov website. And with COVID, at least my hearings have all been through WebEx, and they've been virtual. And I believe that there's some verbiage out there on utcourts.gov that can help everyone become familiar. They are, those are, the primary documents. So memorandum report, that would not be one of the forms on the website, but that is something that you could discuss with an individual. Look like I have some questions over. One was, and I'll read this. What are the financial requirements to obtain these name and gender marker changes? If obtaining both, will you need to pay for the processing of both separately, or is it cheaper to do together? You can seek both a name and gender change in the same case, and from just by sheer volume, I would say that that is the most common way I handle these cases. You request a name change and you request a sex or gender marker change. And the typical price, attorneys vary based on travel time. I frequently talk with attorneys, and this is a flat rate type of case. It's my understanding that the range in fees can vary between, I've heard of some attorneys doing them for as little as $1,000 a piece. I know that the name and gender changes for a minor are typically the most expensive of the name and gender changes. And I know that those can range upwards of $4,000 to $5,000, depending on the attorney fees, which are again approximately $1,500 to $2,500, and then the guardian ad litem fees. And then there is, for most minors, there's a requirement that there be a psychiatric report, which comes with some clinical fees that are quite high. So there is a range. On the low end, I think that they come out at about $1,500. On the high end, I think they can go up to about $5,000 in specific factual circumstances. But it is cheaper to do together. My recollection of the filing fee is that it is approximately $370 or $380. And so if you were to seek a name and gender marker change together, then that would be a single filing fee. And if you were to seek them in two separate actions, then it would be, of course, two. I have
I have a question.
Sure.
Sorry.
No, please.
How much is it to change your name if you're an adult? Can you say that one more time?
My recollection of the filing fee is that it is approximately $370 to $380. I think that there was a recent change in the filing fee. I could be wrong, but it is approximately $370 to $380.
So is that just a filing fee, or is that also to be able to like change my name?
So that would be the filing fee that would allow. So when you file the petition to change your name, you'd pay that filing fee to the courts. So that doesn't go to an attorney, that goes directly to the courts.
Okay.
And once you have paid that filing fee and you submit, if you choose to represent yourself and submit the documents, then there would be no additional fees. However, to get a copy of your order, which you would need to give to the state registrar, excuse me, there are certification costs. I believe it is $5 and then $1 extra per page, but don't quote me on that. And there is also, there might be a fee at the Office of Vital Records and Statistics, but I'm actually not, I'm not aware if there is.
Okay. Okay, thank you.
Certainly. I have a question about, I have a very interesting question from a person, and it states, I was born in California and I currently reside in Utah. When asking around to change my gender marker, I have been given a runabout and told to do the process in California. And then when calling the California office, they told me that since I'm no longer a resident of California, I could do it in Utah. What process would I need to go through? So I can't provide any individual legal advice. I can tell you, talk to an attorney and they can give you jurisdictional information. I do know that there is a California case that is specifically on the issue of jurisdiction. And you may want to speak with another California attorney. I think the information might be old. Regardless of the California information, this is a debated issue, in part because Utah 26-211 specifically states that a Utah district court may issue a order to the Office of Vital Records for a person born in the state of Utah. So the statutory language would suggest, no, if you are born outside of Utah, you cannot obtain a name and gender marker change in Utah. However, there are portions of the the United States Constitution that limit states' ability to draw delineations between the citizens that were born in their state and the citizens that move into their state. So it is a debated topic. There is no ruling from the Supreme Court of Utah on this point. I have personal opinions, and I know that there are judges who have been compelled by the argument that the Constitution does not allow the state of Utah to draw this distinction. So I do know that there are Utah judges who've made that conclusion. As far as an appellate view, this is an undecided issue. One question was about percentages of non-binary people who pursue name and gender marker changes. Unfortunately, I don't have statistical information on that type of, or statistical information. I do know that from my own personal practice, you know, I've represented non-binary people who make a variety of choices in how they proceed with the case. And my argument has always been that the law should afford you the right to choose that consistent with your, you know, your transition and the recommendations of your clinician and your medical professionals. So I don't have any statistical information. I do know that X-gender marker changes are less frequent than either male to female or female to male changes, at least in the legal system. I'm not speaking, of course, of individual person's transition. Somebody said, is there any difference in the filing paperwork for X-gender markers? And again, that goes back to my reference to the form. And I'll answer this question in kind of two ways. If you retain counsel your documents will be individually drafted. I'm sure your attorney will have a form that they use, but it will all be modified to your case. The information of your case is distinct from the information of everyone else's case. And so for that reason, if it's drafted by an attorney, it should include the nuance of your transition. Alternatively, if you pursue this pro se or without the services of an attorney, then you can use the forms on utcourts.gov after searching for the name and gender marker page. The forms that they have do not have boxes. They're not user friendly for someone seeking an X gender marker change, and so for that reason, yes, they do have to be adapted. Somebody did ask, since there are some documents that don't allow for an X gender marker, does having different documents with different gender markers lead to legal troubles? Legal troubles, I don't, you are permitted, you can't force the government to create permissive laws or allowances. So if the state grants you an X gender marker change, but the federal government denies it to you, it will be practical problems. If you have your passport and you give that to TSA and it shows a gender designation that is inconsistent with your gender identity, it could, of course, create an incident. And, same thing with, any other situation. So I suppose the answer to the question is, until there is some uniform consistency, both between the states and between the states and the federal government, there will be practical problems for people who have a document that is inconsistent with other documents, which is exactly why we need legal changes here. We need consistency between the states. We need consistency between the states and the federal government, and it needs to be. We can't forget that the overarching goal here is not to express some sort of viewpoint, but really to allow the government actors to effectively run the country. And they can't do that if there is confusion all over the place in between the government itself and their own documentation on you as a citizen. I had about a tax question, and I'll even tell my own clients I don't deal with tax stuff. But it says, how does it affect tax filings if you are within a financial year when you seek your name change? I would, report it to your CPA. In your trial court order for a name and sex gender marker change, it's going to instruct you, or order you, to inform the relevant people of this change. And that means that you'll need to inform the federal government when you seek a Social Security card and a new passport. It will be to inform the state agencies when you seek a new birth certificate and a new driver's license. But it's also to inform your lending institution for your mortgage or your home. It's to inform credit card companies. It's to inform all debtors so that they have notice, so that there's no argument that you changed your name to avoid a debt. So the tax filing, it will be something that your tax preparer can handle. You just need to make sure that you provide them with notice. There was a question about X gender markers on passports and whether they are allowing them now. It is my understanding that they were allowing them, and that there is a case in Colorado that has pushed back on that. So I'm just simply not aware of the current status, but I do think that I do know people have obtained X marker designations on their passports. There was a question about whether I would recommend a person seek legal help from a lawyer if they are seeking a X gender marker change. I wish I didn't have to give this answer because I understand there are financial implications when legal is involved, but yes, until we have consistency across the board, until we get, until we fully educate judges on why this is permitted under Utah law, there's a legal risk here, and that could negatively impact your rights and your life. And so I would suggest, because of the nature of X-gender marker changes in Utah right now, that it would be advisable to at least discuss with legal counsel your decision to proceed. There are a lot of attorneys who can help you with this. Somebody was asking about referrals. LALU, the Lesbian and Allied Lawyers of Utah, the Lesbian and Gay Allied Lawyers of Utah, are a bar organization with the Utah State Bar. They're an affinity group. And they have a list of LGBTQ-friendly attorneys, and you can access that list from their website, and it will give you a list of attorneys who are familiar with LGBTQ plus litigation or advocacy, and it will be people who to someone else on the list. There are ways. Somebody asked if if doing this themselves will get rejected. No, judges are there to apply the law consistently and appropriately with their interpretation, and so I think we have a great judiciary in Utah who I think really care about appropriately applying Utah law, and so for that reason, I think that you won't just get automatically rejected. The judges are going to try to interpret what they have and not just make a nefarious ruling. That being said, I would note that I don't know what I don't know about tax law, and so I don't know the mistakes I'm missing because I don't know the mistakes that could be there. And so that's similar theory here. It's less about saying something wrong and more so about forgetting to say something that could create a procedural problem that's hard to get out of. Somebody said, so I have a question that says, the previous presentation about name and gender marker changes in Utah said that local judges are, quote, old school and won't approve your request if you don't present as your gender. Have you seen issues with non-binary people getting approvals? For me, presentation has never come up in court, and I would hope that it wouldn't. The 14th Amendment and recent Supreme Court interpretations of laws emanating therefrom or relating to gender or sex itself have given some pretty clear guidance here that discrimination on the basis of sex, whether that be presentation of sexual identity or gender identity, is inappropriate and certainly should not be something that is occurring from members of the judiciary. I think Utah has some amazing judges. I have been in situations where one might think you would face discrimination based on the geographic position of a judge, and I've been blown away by how incredibly informed and dutiful they are. I think judges care in Utah about appropriately applying the law, and I think that it's critical in these types of situations that they have the information they need. Now, is there some misunderstanding here? Is there some bias? Yes, I don't think we have a perfect judiciary, and there are parts of the state where this is much more volatile issue than it is, in Salt Lake County or similar counties or 3rd District. So I have not personally experienced a problem obtaining a gender change or a sex change order for a non-binary person because of how they presented, nor have I, seen judges who are granting these just simply deny them when a person applies pro se. But I do think that there are procedural errors or simply, problems in the paperwork that can happen that can either delay, slow down, or impede the process. So there are judges who disagree with my interpretation of Utah law, my interpretation of 26.211, my interpretation of the common law. And because of that, they have denied requests for gender marker changes, whether from any gender marker changes, including non-binary, to my knowledge. So we need guidance from the Utah Supreme Court. That is clear. And a ruling from them would be beneficial in ensuring that we have consistency. In law school, one of the principal conversations you have is you don't want law to be and be bad decisions because people behave poorly. They pick the judge. And so, having some consistency across the state is going to be vital. Somebody asked, if you are representing yourself and you do not prevail in the district court and you are rejected, what happens? Do you still retain the right to appeal? And the answer is yes. There are timelines that are very strict on appeals, and there are, clear guidelines on those timelines. So if you have received a denial of a X gender designation or any gender marker change request, you need to speak with legal counsel immediately. The faster that you communicate the nuances of your case, the better able your attorney is going to be to decide if you have preserved your rights, if you can proceed with an appeal. The other thing that I would mention in that situation is, given that we have an appeal pending in the Utah Supreme Court on this issue, there are other remedies that people have sought. Many, many, many people are now waiting. Their case has been stayed, which, as it sounds just by the nature of that phrase, is a pause until the Supreme Court rules on the case presently before them. So the advice that I can give people who are trying to represent themselves in a case of where they are seeking an X gender marker designation, I will say this. The University of Utah has a law library that has public access. I don't know how that has been curtailed with the outbreak of COVID-19, if at all, but anyone who is representing themselves can have access to some of the information in that law library. Use it. It is valuable, and it will allow you to make the documents that you submit to the court consistent with what the judges are used to seeing from an attorney. In addition to that, familiarize yourself with the process. Speak with an attorney who does this and get information. Talk with somebody who's done it before and genuinely look at the forms. They do need to be adapted. They do need to be modified, but the modifications are not genuinely complex, and you can do them on your own. And so it is important that before you submit the documents, you review them with a fine-tooth comb. Make sure that they express exactly what you want them to express. Triple check the spelling. Lawyers make this mistake all the time. So just be very, very careful in what you submit to the court and in what the court is reviewing. Make sure that there's no deficiencies. People have waited a long time to get a hearing date because they failed to file a request for hearing. So if you do encounter problems, lawyers in this area want to help. Money makes the world go around, yeah, but people deserve their rights, and that's the most important thing. And so talk with legal counsel. Say, hey, I filed a month ago and I haven't heard anything. See what you can do and see what they can help you with. In addition to all of that, there are a lot of cases that exist in Utah, and you can read some of the appellate court filings. I would encourage you to do so. It gives legal arguments. It gives a perspective into what's being litigated presently. It gives you insight into the weaknesses, or not, well, into the soft points of the law, where a judge might be confused or a judge might have a disagreement. And so pushing on those soft parts is exactly what lawyers do. So familiarize yourself with the case law, familiarize yourself with the law. I've said this probably 100 times in this presentation, but Utah Code 26211 is the source of your rights if you are living in Utah. Look to that statute. The University of Utah's Law Library can help you, and there are some resources that they have available. You can also consider alternatives for your lawyer. For example, some lawyers will consider very low rate review services. Hey, I've got all of my documents produced. I just need you to tell me if I'm missing anything and what. Review it in 20 minutes, half hour, review it in an hour, pay for a limited portion of time. It can be an effective strategy to an intelligent way to attack a financial limitation. So I say familiarize yourself with the law, familiarize yourself with the process. And at the end of the day, in my opinion, there is nothing novel legally about an X gender marker change. You are asking the court to recognize your gender identity as non-binary. You are asking the court to affirm what you already hold yourself out as. You aren't holding yourself out as male or female. You are holding yourself out as non-binary. And so it's the same process, the same arguments, the same philosophies, the same policies. And I think helping judges understand that we're not doing anything novel, we're not pushing the law, we're not going beyond what is accepted. This is simply what is and has been. Are there any other questions? I do have a few kind of finalizing thoughts if there are no. So what I want to leave here with is I am striving to bring, my hope for our appellate court case is that the Utah Supreme Court clarifies this area of law. You should not be going into one district, into one courtroom, into one judge and getting a yes, and then have your friend go into another courtroom and get a no. The sooner we can get that consistency, I think, the better. I think it's going to alleviate a lot of the pressure here. For people who are pursuing this on your own, use the resources, use attorneys, use me, call me. You don't have to pay me. You can just ask me questions, and if I can't represent you, I can get you to the people who can. LawLu is an amazing bar organization that can get you in contact with a host of people who are not me, who are around the state, who do incredible work in this area of law. We need people representing clients down in St. George, down in Sanpete County, up in the northern parts of the state. We have a lot of LGBTQ plus litigators in Salt Lake County, but we have a lot of LGBTQ plus people who are not. And those people deserve representation. So use the resources, and this is ultimately an education for judges. And so when you are drafting your documents, help them understand Utah law. Help them understand why this is not an interesting, novel exploration of a statute, but a simple application. What is a change but a transition from one state to another? We've defined what it is to be a transgender person in Utah, and that is very much consistent with your gender identity. It is very much consistent with a clinical perspective. And that is amazing to me that Utah has taken truly clinical and medical aspect and hopefully applied in a manner that is recognizing a lived life, an identity. So If you have received denials, talk to counsel. If you are pursuing this, look at the forms and be fastidious in the way that you approach them and what you are requesting. I do see a question. If you have a hearing date already scheduled, can you hire an attorney or is it too late? Oh no, you can hire an attorney whenever you want. So, you know, I've represented clients for just a hearing before, and many attorneys do. So if that is something that you are personally considering, yeah, absolutely reach out to counsel. It has been my pleasure getting to talk to all of you. If anyone has any questions about what I've said today, or if you'd like to talk about this further, please don't hesitate to reach out. Law is my passion, and I really enjoy getting into interesting legal issues. And so if anyone wants to discuss it, I'm happy to do so more.
Awesome. Thank you so much, Kyler, for your time and your expertise. I understand a lot of the questions you couldn't really answer specifically to that person, but you have offered your assistance. Can we get your email, or do you want us to call your office, or what is the best way to contact you if we have any questions?
Yeah, so let me restart that. You are welcome to submit an inquiry to our website. It is whartonobrien.com or WorldLawUtah.com. I don't know, but you can just Google it and you'll find it.
Okay.
Our phone number is 801-649-3529. That's 801-649-3529. And my email address is Kyler, Kyler, at WOLAWUTAH.com. So WOLAWUtah.com. You are welcome to email me. Chris Wharton has the same domain name, just his first name, Chris. And, you know, and you can call our office at any time. And even if we can't help you, we have resources across the state who we can give someone a call. And so far, there is not one person in the state that isn't close enough to an attorney that we can find. So if I need to be a broker, happy days.
Awesome. We really appreciate that. Thank you so much again for your time, and yeah, enjoy the rest of your night.
Thank you. Have a wonderful evening.
Thank you so much.